Now turn to the second case on this morning's docket. That is case number 107962, State of Kansas v. Derek Richard.
May it please the court, Joanna Labastida of the Kansas Appellate Defender Office for the appellant, Mr. Derek Richard. If I may, Your Honor, I'd like to request 3 minutes rebuttal time.
30 minutes is granted.
Thank you. And unless the court would prefer otherwise, I'd like to focus my argument today on the first issue raised in the brief and subsequently in the reply brief as well. The first issue is that the district court violated Mr. Richard's right to a fair trial by admitting evidence that Mr. Richard's prior acts of firing his gun in his backyard, they admitted that evidence to show opportunity, knowledge, and identity. Mr. Richard objected to this evidence at trial, arguing it was immaterial to the present charges and aimed at showing a propensity for violent behavior. The test for determining whether or not this evidence should be admitted is whether, the first step is whether evidence is relevant to prove a disputed material fact. And the second step is whether its probative value is outweighed by unfair prejudice. And the third step is giving a limiting instruction regarding that evidence. This court reviews the first question of whether the evidence is probative under an abuse of discretion standard. And but that materiality is determined under a de novo review standard. In the brief, we went through basically every reason that the jury was instructed as to the evidence: opportunity, knowledge and identity, and I believe that's it. And I'd like to go through the previous firing of the weapon in his backyard was not similar enough to this present shooting, enough to make it relevant and probative towards the current crime. Opportunity was not a materially contested fact. There was no question that Mr. Richard was Mr. Lane's neighbor, and opportunity had no bearing on his intent to discharge a firearm.
Well, there is some element that if you don't know how to operate or discharge a handgun, then you really don't have the opportunity. That may go to knowledge, but it seems to me it does at least set up the fact that it's possible that this person could discharge a weapon because he knew how. And I don't know whether that's opportunity or knowledge, but it does seem like if someone's never fired a gun before, doesn't know how to load it, doesn't know how to operate it, then they're less likely to have done this than someone that's admittedly fired their gun before.
Well, I would argue with that on 2 points. The first, the situations with the two shootings were, I believe, I would argue not similar enough to be compared to each other. Secondly, if you're saying that he had knowledge and...
Similar enough in what regard?
Well, in the first shooting, he was testing his gun, and he immediately called his neighbor to let him know that it wasn't anything serious and that he was just testing or letting off steam, whoever you, whatever witness you believe with that. So there was no ill will with that.
Well, that goes to the weight. That goes to the weight of the evidence and how you would view it. But we're talking about admissibility, and the fact that he was in his backyard and fired this weapon previously, admittedly, seems to me is relevant in this case as to whether he stood in the neighbor's backyard and shot at the house.
I would say that the dissimilarity between the two incidents makes it not probative towards the current crime.
But I guess what my colleague's suggesting is that similarity or dissimilarity doesn't really have a role in determining probative value when you're talking about opportunity and knowledge, as opposed to, for example, signature, plan, those sorts of things. He's just suggesting if the gentleman were on the stand and his counsel handed him the gun and said, load it and prepare to fire it, and he sat there and said, I don't know how to do that, which would be true of some people, that would have bearing on the case. And this incident demonstrates that he in fact did know how to do that. So I don't think your similarity argument helps you much. What's your other argument? You said you had another argument.
And it's completely escaped me now.
Okay. My
Apologize.
colleague had asked you about, that fact that sets up opportunity or knowledge, and you said you had two responses, and you said the situations were not similar enough, and then we started arguing with you. Do you remember what the other one was? It'll come to you.
Right.
Okay,
And
thank
I
you.
probably was going to argue that whether or not you agree that it was for that particular purpose, opportunity, or knowledge, I would argue that it's more prejudicial than probative when it comes to those two, and identity similarly, far more
That
prejudicial.
definitely was an issue.
Yes.
And tell me why it's more prejudicial.
I think when jurors hear that this defendant shoots guns in a neighborhood, in his backyard, up in the air, he admitted to shooting it up in the air, and for this particular instance, over the house as well, not at the house, but over the house. I think that just generally gives the defendant a bad rap, basically, as someone who...
That's what I was sort of reading in the brief, and it seemed to me that your argument on prejudice is what makes it relevant.
Also, wasn't there other testimony that he admitted to shooting the gun the night of a different night, the same night as the person was hurt? That he was on his way home and shooting it in the street or something? Wasn't there some?
No, he was in the backyard.
They were all the same
acknowledged
incident?
being in the
Okay.
backyard, and that's how the spent rounds got there. The only dispute was whether he shot in the air or shot at the house. Isn't that correct?
I agree, yes.
On the night of the crime.
On the night of the crime, whether he was
So
shooting at the window
there's
or not.
two different incidents where he's shooting in the air.
Yes.
And one of those was coming in, because it was the night of the crime.
Right.
That was his defense. Oh, I didn't shoot at the house.
Which is yet another reason this basically is propensity evidence, which this court has held that is not a proper reason for evidence to come in.
How's it propensity?
If he,
I mean, the issue is whether he intentionally shot at the victim here through the window, not whether he had a propensity for discharging a firearm in town or in the backyard.
well, his argument was that he was shooting in the air. I see what you're saying.
But are you saying he had a propensity to commit the crime of unlawful discharge of a weapon, and so therefore that would mean that he's predisposed to murder someone?
I think that the jury could see that, that his recklessly or being kind of a menace to the neighborhood by shooting in the air, and that he's done it on a prior occasion, would mean that he has a propensity to unlawfully discharge his firearm in the neighborhood, which was the underlying felony for this felony murder. Just briefly, I'd like to address the state's reasons that this could have come in as well that weren't addressed by the district court. In our reply brief, we point out that those were not ever addressed by the district court, and that although this court has held in State v. Reed that if this court finds that those are proper reasons, basically it's harmless to allow them in for potentially an improper reason.
Seems to me your arguments why Reed shouldn't apply go more to the limited instruction. I mean, I can see how if the jury's instructed that you're limited to view this, in this case it was identity, knowledge, and or opportunity, and then the state argues later intent was the relevant issue, the jury really didn't get an opportunity to make the determination. But what you're talking about, you're not challenging the limiting instruction, you're challenging admissibility, whether it was admissible, not whether it was admitted correctly, but whether it was even admissible. And so I see a distinction on applying the Reed rule of if any fact would have let it in, then it wasn't reversible error to admit it, even though the limiting instruction may have been erroneous or clearly erroneous. You see that distinction?
Yes, and I would argue that if this court found that those reasons, which we are arguing is not, they were not proper for admissibility, that those reasons are erroneous, that the state should not be able to argue on appeal that any other reason would have been proper.
In order for Reed to apply, the reason has to have been one of the ones in the instruction.
I'm sorry, could you repeat that?
I'm sorry. In order for Reed to apply, the reason must have been one of the ones given in the instruction. That's what you're saying,
Right. Yes. And so we would argue that none of those reasons should apply for the admissibility. And so for the state to argue on appeal that another reason would have been proper is, and I know that Reed is the current state of the law, we would argue that that was wrongly decided. Because 6455 evidence is different than other types of evidence in the effect it has on the trial, and this court's prophylactic nature of the limiting instruction and basically how it affects the trial could be different than other types of evidence.
Before you run out of time,
Yes.
I want you to address, if you would, the state's preservation argument. They said that the defendant didn't object during his own cross-examination.
Yes. I would argue that because the defendant objected two previous times, the first two times that the evidence was discussed, he basically had to deal with it somehow, and by his own testimony on cross-examination, and actually on direct, I believe, as well, he was dealing with that evidence. I don't know that he has to object to that to preserve it. The purpose of the contemporaneous objection rule is to give the opportunity to the district court to potentially change its decision based on the evidence that's come in so far. And he gave the judge that opportunity twice, and after that, I guess, believed that it wasn't going to change, and so he had to deal with it himself.
Why not lodge a continuing objection? That's what bugs me about this. Because counsel obviously knew how to do that because they did it on another issue about what was found during the search. So I'm really bothered by the preservation, and I don't know how you form a rule that says, well, we objected a couple of times early on in the case, so it was okay for us to just give it up without making a record and saying, I don't want to disturb the trial or the jury or get anybody mad at me. I mean, we all understand that, but the way you fix that is just to get it on the record that you have a continuing objection and you're done.
I agree, and he obviously knew how to do that based on issue number 3 with the continuing objection. All I can argue is that we're trying to deal with it as best we can on appeal, trying to raise the issues that needed to be raised, and that's my argument, that the district court had the opportunity to change its ruling a couple times, and it was sufficiently preserved at that point.
Any further questions of counsel? Thank you.
Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I also will be limiting my remarks to issue 1 unless this court has any questions about issues 2 and 3.
I want to talk about the preservation right up front. Once the court says this evidence is coming in, how does a defendant try to spin that in his or her own best interest, which is what defense counsel has to do, try to spin it to defendant's benefit while still objecting to it? I mean, that's pretty ludicrous, isn't it?
I would argue not. I don't think there's anything inconsistent with a defense attorney lodging a running
But the court
objection.
doesn't have to accept a continuing objection. We've had cases up here where the judge says, no, I'm not going to grant you a continuing objection. You have to object each and every time. I'm not going to take that on myself. We'll see what context it is. And in that circumstance, assuming the court does that, and we've said, hey, that's the judge's courtroom, and they can do that.
Well, two things. First of all, I think that's a dangerous assumption to make, that it would happen in this particular case. Second of all, if it does happen, then the defense attorney still has the ability to lodge the objection at each appropriate time, which is what King and the contemporaneous objection rule tell us is supposed to happen. In this situation, it wasn't merely a matter of the defense trying to spin it to his favor through his own testimony. It's also important to remember that he didn't object when Detective Chisholm testified about the 455 evidence. So we have more than just the defense trying to use it in any way they can when the defendant gets on the stand. We have an entire witness, a state's witness, who testified about the 455 evidence that the defense did not object to as well. So I think, first of all, I think the proper step for the defense attorney to follow is up front, if he or she chooses, to ask for a contemporaneous objection or a continuing objection. If the court does deny that and tells counsel that he wants him to lodge a objection at each appropriate time, then certainly there's nothing difficult about a defense attorney getting up and saying, "Objection, Your Honor, pursuant to pretrial argument." And then if the court denies that, the issue has been preserved. When the defendant is on the stand himself, counsel can then go about trying to deal with the issue or rehabilitate his client in whichever way is possible. But I certainly, as I argued in the brief, don't think that an objection to one witness, or in this case, two witnesses, is sufficient to preserve an issue that then comes in also through a witness that testifies several witnesses later.
Plus a limine. Didn't we have a motion in limine to start?
Yes, it was
Okay,
limited,
so
yeah.
we had a court order in order of limine that allowed it, and then we had two objections at trial.
Right.
And your complaint is that we didn't have the third and fourth objection.
Right. And I'm not arguing that he is unable on appeal to contest the evidence that came in through the two witnesses that he objected to. I concede that that is preserved. He is entitled to challenge the testimony that came in through, it was the victim's wife and one of the law enforcement officers. I would not stand up here and argue that he's barred from raising that issue on appeal. But where the failure to object becomes relevant is that, first of all, he's not entitled to challenge the testimony of Detective Chisholm or his own testimony, and he's not done that. But even more critically, it comes into play down the road if this court were to determine that there was any error in admitting the evidence through the victim's wife, is it comes into play at harmlessness, because the same testimony would have come in, and in fact did come in unobjected to, through Detective Chisholm and through the defendant's testimony. So in any harmlessness analysis, this court would have to recognize that the same evidence came in unobjected through other sources, and therefore he cannot show that this testimony through the one particular witness was reversible error. Turning to the facts of the case, and as far as what this evidence came in for and what the evidence was, pre-trial it was litigated, and the court initially indicated that it was going to admit it for opportunity, knowledge, identity, and intent. However, for whatever reason, and there's no explanation as to why, intent did not end up making it into the limiting instruction that was given.
And did the state object to the omission of intent in the limiting instruction?
Not that I'm aware of.
Then why are you preserving intent as a basis for admission?
Well, there's a difference between an evidentiary objection and a jury instruction issue. To the extent that the question would be, did the state preserve the issue? Certainly this court all the time reviews jury instruction issues that the instruction is not objected to. It might affect the standard of review to the extent that there's an issue about that. But as far as this is not an evidentiary. The state didn't fail to preserve an evidentiary issue for review.
But if we follow the rule that you often cite to us, that we presume the jury follows the instructions, if we do that, then the jury was precluded from considering this evidence for intent or for the other reasons that you provide in your brief,
Right.
don't we?
Well, I think to that, with respect to the Reed and Boggs line of cases, and I understand defendant's argument is that 6455 evidence is unique and it should be treated differently than other types of evidentiary issues, and that's why the right for the wrong reason or right for any reason analysis shouldn't apply. Of course, my position is that this court was correct in saying in those cases that if there was error in admitting it for any of the reasons listed, that you still can uphold the district court if other bases would have been correct. I think that to that issue, you really need to look at what is the overall purpose of 455 and the statute that bars evidence of prior crimes or civil wrongs. And it's not, the rule is there for a specific reason. It's to prohibit propensity evidence. You don't want evidence coming in just to show that the guy is a general wrongdoer, that he's got a propensity to commit crimes, and that because he did something on a previous occasion that you should go ahead and convict him just because of his prior conduct. So even if the particular limiting instruction doesn't list the proper factors under the statute or the non-statutory factors, the very fact that there is a limiting instruction does eliminate the main problem that 455 seeks to address. You've already told the jury that it cannot consider this. You've prevented the jury from considering it for propensity purposes. So to that extent, while there is a difference between 455 evidence and perhaps other types of evidence, I think that right there cures a big part of the concern. So you're
telling the jury, if you tell the jury you can consider it for a material fact that doesn't apply, that isn't correct, that's okay. We can assume they didn't consider it for propensity. Is that what you're saying?
Well, I think you always, regardless of whether the labels or the factors that you put in the limiting instruction are the correct ones, the limiting instruction itself, that's the whole purpose of the limiting instruction, is to avoid the propensity concern. So yes, I think regardless of whether the instruction says identity, intent, motive, opportunity, or non-statutory factors, you've eliminated that concern.
Counsel, I think I was with you until you said the whole purpose of the instruction is to eliminate propensity, and that's not really quite right.
Correct.
50% of the purpose is to eliminate propensity, and 50% is to
that would
guide
be
them.
overstatement, and certainly I would agree with that. It's not the only purpose, but and I think it also illustrates that and I think some of the questions to opposing counsel illustrated this also. A lot of times, this 455 evidence, to me, the hardest part is the labels. You can agree, or perhaps some would agree, that the evidence belonged in the case, but then trying to figure out, all right, which one of these statutory factors, or is it a non-statutory factor, does it actually apply to? And when you look at this case, it appears to me that the parties at the pretrial hearing were on the right path as far as why this evidence arguably was admissible, but just ended up giving it the wrong labels. And in some circumstances, it's because I think that the definitions in the legal terms, especially for something like knowledge, don't necessarily match up to what you think of when you hear that word in just an everyday context. But in this particular case, our argument is that when you look at the evidence of the prior shooting, that is relevant because the defense in this case, there were really two theories, I guess you could say, that he advanced, either through his testimony or through his statement to police. One was that I was just shooting in the air that night. I wasn't trying to shoot into the house. I was trying to send a message. There's no way I was shooting into the house because I consider the victim's son to be my little man. I would never risk hurting him, so I was just firing up into the air. He did at one point in the interview seemingly acknowledge that his gunshots entered the home because he made this statement about how he was hoping he could somehow work out a deal for a manslaughter conviction, which would seem to imply that he does recognize that his bullets caused the death. But then on the other hand, there were other points where he also suggested that no, my shots didn't go into the house. But in any event, both of those theories, he was saying that he was firing into the air, not into the house.
One theory was he was shooting in the air, and what's the second theory?
Well, they were both that he was shooting in the air, but it was that at one point he seemed to acknowledge that his shots did accidentally go into the house. At another point, he was still seemingly suggesting that his shots didn't actually enter the home. So in either scenario, he was claiming that it was accidental. Because he made his intent in firing the shots an issue, then clearly that was a disputed material fact, and the defense acknowledges that in their brief.
The disputed fact in all this is once he admits that he was in the yard and shooting the weapon into the air, the only disputed fact is whether he was aiming at the house, because he has to intentionally shoot at the house.
Exactly.
To have to violate the felony with which he's charged, right?
Right.
And why does the fact that he has shot in the air before make it more probable than not that this time, instead of shooting in the air, he was aiming at the house?
Well, I think it has, when you're looking at this evidence and whether evidence is relevant, it has to have any tendency to prove one of the disputed facts.
That's my question.
And
Why
I
does
think it clearly
tend to
does.
prove if he says before I shot in the air, everyone agrees he shot in the air. This time he says I shot in the air, not at the house. Whether they went in there or not, why does it tend to prove that this time he was really shooting at the house?
Because I think that his defense is clearly more plausible, although I wouldn't say likely, but it's more plausible if there's no indication that this guy has any clue how to fire a weapon. I'll use myself as an example. I've never touched a gun. I've never fired a gun. I think that a jury would be more likely to believe that defense if I could say, you know what, I was firing in the air, I have no clue what I'm doing, and accidentally the shot entered the house instead. I'm a really lousy shot. I don't know my way around firearms.
But what does that have to do with intent?
Because it shows that this man knows and is capable of firing shots into the air without striking his neighbor's house, if that's truly his intent. If he really was in the victim's backyard on the night of the murder, intending to fire shots in the air and not hit the victim's house, he's proven he can do that. On this night, he'd fired into the victim's house not once, not twice, not 3 times, but 4 times. And I think any juror hearing evidence that on a prior occasion he fired into the air safely, as it were, that would have a tendency to convince those jurors that, you know what, his defense is simply not believable here. And so for that reason, and intent, as the case law tells us, intent and absence of...
I understand that precisely. The fact that there were 4 rounds that went through a window, one of them hit the victim in the head, makes it incredible that he was randomly shooting in the air. But that doesn't answer my question. My question is, why does shooting in the air on a prior occasion show he had an intent to shoot at the house on this occasion?
Well, again, I think my answer, and maybe I haven't articulated it, I've certainly attempted to, it's that it shows that he is capable. The fact that the prior episode shows that when his true intent is to fire into the air, not into the house, he's capable of doing it. And therefore, when you look at the current episode, it does make that defense much less likely that he was intending to simply fire in the air because he was blowing off steam or sending a message.
He'd been successful before, and he could have been successful this time. Unless
Exactly.
he intended to hit somebody,
Exactly.
or the house at least.
Shoot,
Okay.
yeah.
Right. And I think, intent, as the case law tells us, intent and absence of mistake are very similar in this situation. And the argument is really the same on both of those two factors here. It's just that his defense, his theory is that that the shots entered the house accidentally. And our argument is that prior episode shows that was not, in fact, the case, or at least it has a tendency, in fact, to show that.
And just so we're clear, the jury was not instructed on either intent or absence
They were
of
not.
mistake. Okay.
They were instructed, and the next one that I brief is knowledge, awareness of wrongdoing. And in that factor, I would ask the court to look at and contrast his behavior on the night of the murder with his behavior on the prior occasion when he fired into the air safely. On that prior occasion, he called the victim to explain why they might have heard gunshots and said he was just blowing off steam, or he might have, I think that was when he maybe to the neighbor explained that he was just testing out the weapon, that he had this new weapon and he was just testing it out. Obviously, no such phone call occurred on the night of the murder. Another difference is that on the night of the murder, he took the gun and hid it in this room, and he admitted in his interview to police that he hid it because he didn't want the police to find it. He didn't take that step on the night of the prior episode. So that those are steps that show an awareness of wrongdoing. He's hiding the weapon because he obviously knows that the police might be looking for it. He's not calling the neighbor to explain that he was just out firing his gun. So I think when you contrast the prior and the current episode, that does show that he had an awareness of wrongdoing. I know I'm out of time. With the court's permission, just briefly, I'd note that I also briefed a couple of non-statutory factors in this case. One is that this evidence simply explained the course of the investigation. It was through the victim's wife that the police learned that the defendant became a suspect, because the wife talked about how the neighbor was somebody to look at because he had previously called them up and said that he had been shooting the gun out in the behind the houses, and that's essentially how the police first developed him as a suspect. So the evidence also served that purpose. So there are numerous reasons, and again, I will acknowledge that not all or not even many of those or most of those were listed in the instruction, but I would ask this court to adhere to Reed and Boggs and find that nevertheless the district court was correct. One final thing, if this court does agree with the defense that Reed and Boggs were incorrectly decided, I'd simply ask the court to fold that analysis into a harmless error type, whether you're saying it's right for the wrong reason or just developing it as a harmless error analysis. The result ultimately would be the same, that this evidence was properly before the jury, and therefore there was no error that necessitates reversal. If there are no
Any
further
more
questions, we would respectfully request that the conviction be affirmed. Thank you.
Thank you, counsel.
Thank you.
Having outlined my previous arguments, I waive rebuttal.
Any further questions?
I just want to clarify that on the preservation of defendant's statements, he didn't challenge at trial, didn't object at trial. How's that preserved?
Well, it was not specifically discussed in the brief, so I don't want to risk adding new points, but I would argue out of fundamental fairness to the defendant, this error be reviewed.
But wasn't there a video of the third interview that was played to the jury, which was the one that I think is particularly damning to the defendant, and there was no objection?
As far as I could tell from the transcript, that's correct.
In fact, I think didn't the defense counsel may have said no objection. And so, under those circumstances, how do we review it?
Well, I guess I would focus my argument then on the limiting instruction not matching up with the motion in limine ruling, and the state's arguments on additional factors that it could have been admitted for.
Any further questions? Any further presentation?
No, Your Honor. Thank you.
We thank both counsel for your arguments this morning. Court will take this matter under advisement.